You're listening to the Hidden Killers podcast with Tony Brueski,
featuring author, guest, and criminal defense lawyer Lori Hellis.
Lori Daybell's request and appeal that's going on right now, or at least has been filed, mainly focusing on not necessarily the merits of the case of what happened, but more so on her mental acuity, her mental well-being of even being able to stand trial. Things many of us had been waving red flags of at the beginning, going, is this really right? We want to see justice, but at the same point, can you see justice with someone who can't basically see any form of reality? And that's what's being argued right now. What's your opinion on the merits of that, and also considering the fact that Idaho doesn't really have a whole lot of grounds on mental health for standing trial or insanity?
Well, Idaho's a little bit interesting. However, doing away with the insanity plea in Idaho was a little bit of a what do they call that game where they hide the marble, you know?
Oh, sure, yeah.
A little bit of a bait and switch, you know, because there is an avenue still in Idaho to claim that a person didn't have the mental state to form the intent to commit the crime. It's a little bit like splitting hairs. So I would say that it is a little bit more narrow definition of insanity, but still, what Idaho says is, yes, we don't allow someone to use mental health as an affirmative defense as the way it has traditionally been used. But we do allow someone to argue, Your Honor, my client didn't have the mental state to knowingly commit a crime or to intentionally commit a crime. So it is a little bit of a dance. So they did have the opportunity during her trial to say to the court she didn't have the ability to form the mental state to commit the crime. They still had that opportunity, but she wouldn't allow it. It was very clear in court that she had told her attorney she did not want to use that mental defense. So they weren't able to do that. But, and of course, there are two different places where we talk about mental health. One, when the crime is committed, was the person sane at the time they committed the crime? And then two, are they able to aid and assist in their own defense? So they did not raise at trial the issue of her mental state because she wouldn't allow it. But clearly, the judge made findings about her competency to stand trial. So they're really going back and saying, Your Honor, she never should have been tried because she wasn't competent.
Sure.
So that's sort of what they're going at. It's interesting because in late September of last year, when the trial was still set for January of 2023, her attorneys filed a new motion expressing concern about her competence.
Sure.
And that was when we got into the whole issue of having to move the trial beyond her speedy trial window, because it was her lawyers who filed a motion and said, we don't think she's competent. And the judge put everything on hold, vacated the court date in January, and then they had a new evaluation. And during that evaluation, after that evaluation was over, of course, those evaluations and the proceedings having to do with her competency were sealed. So we don't know exactly what happened in those, but we do know a couple of interesting tidbits from that proceeding. First of all, we do know that the prosecution brought in Michael Wellner, and he is a very well-known psychologist. He's a psychiatrist. He is the psychiatrist who decided that Brian David Mitchell, who kidnapped Elizabeth Smart, he was the one who proved that she was competent after about 8 years of him putting on that he was mentally ill.
Mm-hmm. So there's some history there where he's able to, or he has been able to go and show those sort of things. Again, it is an opinion of a doctor. At some point we got to go, who's the expert here and who knows, this better than other people? He certainly, you'd think, would be one of them. But I guess then that kind of goes back to, you were talking earlier, they did not use the mental defense in the actual trial. They could have. They did not, because she did not want them to. I guess, why now? Is it where her back's against the wall and there are no other options at this point?
Well, I think so. I think the other thing is that the attorneys don't feel quite so constrained by what she wants, because the trial is over. Mm-hmm. And so they're bringing it up because it becomes the basis of an appeal for her lawyers to say, the judge made an incorrect ruling when he ruled that she was competent. So it is an avenue for them to challenge the trial and still honor her desire not to raise mental health in the trial, if that makes sense.
You're consuming the Hidden Killers podcast.
Want more? Start binging on all of our true crime podcasts right now through Apple Podcasts and get an ad-free experience when you sign up to be a True Crime Today Premium Plus member exclusively on Apple Podcasts.
More of the Hidden Killers podcast dropping soon.
Press subscribe now.